Please, circuit court is now in session. The Honorable William Stone presiding.
All right, good morning. Be seated, please. All right, Mr. Durrell.
Morning, Your Honor. May it please the court, Dustin Durrell. Your Honor, I have Mr. Jackson Spa, 23 CF 1303. Your Honor, this was set for a motion for bond on the violation of probation. However, discussion with the state and my client this morning, we do have a written plea that would resolve the matter.
All right, you may proceed.
Looks like it.
Yeah.
Something will email that next.
Yeah, I'm good with that.
May I approach, Your Honor?
Granted. And Mr. Durrell, you've reviewed the score sheet. Any score sheet objections?
No objections, Your Honor. We have reviewed it.
All right, you may proceed.
Yes, Your Honor. At this time, Mr. Spa would admit to the violation with the understanding that probation would be reinstated and modified to extend an additional 12 months. The $50 VOP fee, 50 hours community service that may not be bought out must be performed. Any outstanding conditions or conditions will be reimposed. Any conditions completed, obviously, will still be satisfied. Maintain withhold of adjudication. I think I neglected to put that on the plea form if I need to add that, Your Honor.
No, sir. You marked it.
Thank you. I believe that's all the terms.
Correct, yes, sir.
And that's the state's agreement?
Yes, sir, it's a maintain and withhold.
Yes. All right. Raise your right hand, please, Mr. Spa. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you can put your hand down. You heard what Mr. Durrell said, and you signed the written plea form.
Yes, Your Honor.
Do you understand by this plea arrangement that you're admitting the violation?
Yes, Your Honor.
And that tells me that you agree that you violated your probation just the way the affidavit report by your probation officer says you did?
Yes, Your Honor.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, Your Honor.
And in this case, the agreement with the state is that your probation will be reinstated and modified to extend it by 12 months. And that's 12 months from the original expiration date, is that right, the termination date?
Yes, sir.
Yes, Your Honor.
All right. And add the 50 hours of community service to whatever else whatever else already existed on the community service hours. And you can't buy those out. You've got to perform them. That's part of the agreement. Do you understand that?
Yes, Your Honor.
All right. And then you'll have the VOP fee. It should be 100 though, shouldn't it?
Was it 100? I apologize. The VOP fee is at $100.
Correct, yes.
Extra $50 on the VOP fee.
And then all the other conditions will be reimposed that have not been completed. Is that what you understood?
Yes, Your Honor.
Okay. Mr. Durrell answered all your questions about the plea and how it affects you.
Yes, Your Honor.
And are you satisfied with how Mr. Durrell's represented you?
Yes, Your Honor.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Probation is going to give you some instructions as you walk out, so take a brief moment to engage with them. And you need to report as soon as possible. I know there's some issues with transportation right now, so if you don't get out in time today to report this afternoon, then you're going to have to be there the very first thing in the morning, okay? You understand?
Yes, Your Honor.
Okay, thank you very much.
Your Honor, may Mr. Gomez and I approach briefly?
Granted.
I believe that's all I have, Your Honor.
And Mr. Jarrell, thank you for being a friend of the court in that regard.
Thank you.
Good day. You got that. You got those two. Okay. All right, Ms. Jaquick, please. Oh, I'm sorry, Mr. Cotton, I apologize. Well, and I apologize, Ms. Jaquick, because with the transportation challenges, we're trying to accommodate transport, and they've got the inmates lined up in a particular way. I apologize.
No problem, Judge.
Thank you, Your Honor. Good morning.
Good morning, sir.
Your Honor, for the record, Byron Cotton present with Robert Rosario, R-O-S-A-R-I-O, case number 25-CF-1068. Your Honor, we've reached an agreement in this case, and I have a plea with the guideline score sheet, if I may approach.
Granted.
Do you still have that misdemeanor case number up?
Good morning, Mr. Cotton. You may proceed, sir.
Your Honor, may I have the plea agreement back? I'm sorry. I normally announce, but I'm going to do it.
Very good. There you go.
Your Honor, pursuant to an agreement with the state, Mr. Rosario would be tendering a plea to counts 1, 2, and 3, pleading no contest as charged. The terms of the agreement would be that he would be sentenced to 5 years sex offender probation concurrent on all counts. He would complete a sex offender evaluation and treatment, He would not be able to have any contact with minors, not be able to be places where minors congregate. He shall have no internet-capable devices, including smart televisions. He shall notify his employer of his probation and sex offender status. He shall have no alcohol and drugs. He'll have $666 in court cost, $40 a month cost of supervision. Adjudication will be withheld. A PSI is waived, and it is a stipulated downward departure. May I correct?
Granted. And any score sheet objections?
No, sir. This is his only evidence.
State?
Yes, that's the agreement, Your Honor.
All right, thank you. All right, raise your right hand for me, please, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you can put your hand down. You heard what Mr. Cotton said, and you signed the written plea form.
Yes, Your Honor.
How old are you?
20.
And how much education do you have?
I graduated high school.
You able to read and understand the plea form?
Yes, Your Honor.
Did you do that before you signed it?
Yes, Your Honor.
Information is filed on this.
And is what you read in the plea form what Mr. Cotton just announced to me?
Yes, Your Honor.
Do you understand by this plea arrangement that you're pleading no contest to the announced charges?
Yes, Your Honor.
And that says to me that you believe the state has the evidence necessary to convince the jury of your guilt, and you're not going to contest that. And do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to present that evidence to the jury and convince the jury of your guilt beyond a reasonable doubt?
Yes, Your Honor.
In this case, adjudication will be withheld, and you'll be on 5 years of probation with sex offender conditions. And the evaluation, no contact with minors, not be at places minors congregate. The issues regarding the internet-capable devices, including the televisions. You must notify your employer of your probation and your status. Does this end up being with a designation?
That was not. I think the withhold kind of addressed that, but.
I don't think it addresses it because it can still be a withhold, but I was going to ask for it.
Well, why don't y'all put your heads together real quick, because that's a material issue that we need
Sure.
to address.
Yep.
Okay, I'll turn this obnoxious noise on for you.
Your Honor, I believe that the agreement is that there would not be a sex offender designation to go with the withhold.
That's correct.
Okay. All right.
Wasn't me, Judge.
You gotta love technology, don't you? All right. So, and you've got to notify your employer of your probation and your sex offender status. Now, one of the things that's not addressed in here is that access to devices would be allowed under supervision directly at work and so on, correct?
Yes, Your Honor.
Okay. So it would be clear that it would be allowed as a condition of probation. However, probation has a protocol where they allow that as long as they're properly informed, okay?
Would you like for me to add that to the written plea, Judge, or do you think they?
No, I think that's,
Okay.
that'll be okay. I'll just supervise, accept it as supervised at work. Because that's part of the issues of informing the employer of the status so that they then have the cooperation with probation if access is required. Otherwise, if they're not informed, then when probation calls, then they go, so we want to close the loop on it.
Yes, sir.
And then you have the fees and cost and the supervision. Is that what you understood the plea agreement was?
Yes, Your Honor.
Okay. Has Mr. Cotton answered all your questions about the plea and how it affects you?
Yes, Your Honor.
And are you satisfied with how Mr. Cotton's represented you in this case?
Yes, Your Honor.
The court will find the plea is freely and voluntarily entered into and will accept the plea with the withhold at this time. Now, before you leave, probation is going to have a brief conversation with you and tell you what you need to do to report, okay? All right, thank you very much. Mr. Cotton, anything else for you?
12:30, I'll see you then.
Okay, thank you.
Thank you, Judge.
Who are you on at 12:30? Mr. Cotton?
Thompson, he didn't have my, it's not on there. The bailiff has added me to the docket. I think we can file a late notice on that.
He's here though.
Well, it's a pretrial detention issue that I need to finish talking to Mr. Snell about, so I'm not sure. We don't have that resolved as of yet, Judge.
Okay, well, with the transport issues, if Mr. Snell's free and you can chat about it, and we can move Mr. Thompson down off that docket to accommodate, I mean, I don't know what the state's intentions are.
If it's gonna be.
I'm actually really just now talking to Ms. Doris about it, so we're trying to finalize.
Okay,
that.
so
I'll
if
tell you
you,
what, I'll hang around for a few minutes, Judge. I've got to go
Very
up to
good.
Judge Clark for a moment anyway.
absolutely,
I'll come
perfect,
back
thank
in.
you.
Thank you.
All right, now after the false start,
Shannon, stop.
Ms. Jacob.
Thank you, Your Honor. Your Honor, this is Shannon Stell. She's before the court today in 25 CF 1425. This is the case that was transferred down from Crestview a couple days
Correct.
ago. I'm not really sure why it got set for arraignment again, because we filed a written plea of not guilty months ago on this case. However, at this point, I'm just asking that the court set it for pretrial conference on May 11th. I do realize she has another case. I do realize that case is technically set for the July docket. However, there was a revoked bond on this case, and so I'd like to see if we can maybe work this case out at a minimum.
What's the other case number, and we'll.
26 CF
697, Your Honor.
697.
2026 CF 697.
That's correct, Your Honor.
All right, Madam Clerk, advance the 697 case from July to May.
Absolutely.
Okay. Just double checking. That case is brand new, and I was actually just discussing it with Mr. Gomez, the weird way that this lower case number got transferred down rather than the other cases following the lower case number. Yeah, I don't know what happened. Something happened in the north end. They, I'm sure, had some reason behind it, but because of that, it's weird, and I was not sure if the cases were gonna remain with Mr. Gomez or go to Mr. Snell, now that technically she's gonna have the lowest case number because it's a 25 versus a 26. And I wanted to make sure we were getting our demand to the correct person, so there wasn't a delay in getting discovery, so I just wanted to double check, so I apologize.
No, that's okay, ma'am. You know, as long as you're communicating and move the case forward, I don't object to that.
But
No
yes,
problem.
so that would be perfect. If we can have them both on May 11th.
If you're
we
talking
can't
ball
get them.
scores or where you're gonna eat lunch, then I might have a problem.
That is one thing that they have not goaded me into yet, so I'm free on those ones.
And so with understanding that because it is a brand new case, but I'd rather have them travel together, so if we have the opportunity to do something, then they can go together. So, Madam Clerk, 1425 and 697 for pretrial conference on 511. Okay? And you're denying on the VOP?
It's not a VOP, Your Honor.
It's a
I know it seems like it's a VOP. They put it, when it was docketed by the clerk's office, they got docketed as a VOP arraignment. However, it should never have been a VOP arraignment. It was just that Judge Oberleeson set it as an arraignment date for this morning. So, and I understand that someone probably looked at it and thought it was a VOP because one, the lower case number was getting transferred down, and two, it's a 25 case. So, but it is not actually a VOP. It is a new law violation that has not yet been resolved. You talking to me, TJ? Sorry. You talking to me?
And so that is some confusion on the docket.
Because if it was a new law arraignment, it should have been at 1:30. But the judge's order said today at 9. So I think the assumption was that it must have been a VOP arraignment,
Correct.
not a new law arraignment.
Correct.
So, but regardless, we've already entered a written plea of not guilty, so
I see
all
that.
of the steps have been completed.
Correct. All right, so we'll set that for 511 along with the new case, and let's see if we can move forward. Are you in a position yet to make an offer to resolve the cases?
Not yet, Your Honor. To be quite honest, I just realized that this case, we're still trying to figure out between me and Mr. Snell who is going to be handling the cases. I'm going to make sure that gets accomplished in the next 24 hours. And then when we send out the discovery, we'll be ready to make an offer, Your Honor.
All right.
And this is a constructive possession case, Your Honor, that I already spoke with Ms. Stell, that I believe I might be filing a motion to dismiss in, which may help the state make an offer. So I will expedite getting that done and make sure that's done right
All right,
away.
very good. Very good. Thank you very much, Ms. Jacob. Thank you, Ms. Stell. We'll see you on 5/11. Good day.
Barbara McNamara?
McNamara.
And Your Honor, we had some last minute dealings with her misdemeanor case as well. I do have a written plea agreement for both the felony case and the misdemeanor case. However, the first thing I need to ask the court to do is order that the court now finds that she is competent to proceed and the case may move forward.
Does the state stipulate to the acceptance of the report?
It's stipulated, Your Honor.
All right. The court finds that the defendant is able to proceed at this time.
Thank you, Your Honor. And Madam Clerk, the misdemeanor case number is 25MM1401, and it is one count of petty theft less than $100, a second-degree misdemeanor. And just briefly, Your Honor, essentially, Ms. McNamara had pled to a probation sentence prior to us realizing there was a need for an evaluation on Ms. McNamara. And based on the fact that she's now been in the county jail for a year at this point, the state agreed to allow her to withdraw that plea and be resentenced to 60 days with their stipulation that she has the 60 days. I have a written plea agreement outlining the new sentence. I just need the court to grant the motion to withdraw plea as to the prior sentence.
On the misdemeanor.
On the misdemeanor, yes, Your
Right.
Honor.
And we're doing this as a convenience to the supervising judge in county court.
That is correct, Your Honor.
What I understand is that's the magic language we have to use if we're taking a plea for the county judge.
I just got that order, so I have not had an opportunity to read through the language yet, Your Honor, but I do understand there's some special
All
language we
right.
need.
So we're taking this misdemeanor plea for the convenience of the county judge, and the case, the county judge should remain assigned.
And Your Honor, I'm just going to pause briefly. I already discussed all of this with Ms. McNamara, but I got the agreement from the misdemeanor state attorney after I met with her, so I just need to have her. And Your Honor, how would you like me to start, with the misdemeanor or the felony?
As you please.
Okay, let's start with the misdemeanor. I've got it in my hand. 25MM1401, that is one count of petty theft less than $100. Based on the stipulation with the state agreeing to it, I would ask that the court grant the motion to withdraw the previously entered plea and allow Ms. McNamara to enter this written plea agreement where she will be pleading to an adjudication of guilt, 60 days in the county jail. She will receive credit for 60 days by stipulation, $270 in court costs, a $50 cost of defense. She'll need to pay $75 in restitution to Walmart at 748 Beale Parkway in Fort Walton Beach, and her financials are due within 120 days on that case. Would you like me to approach separately?
Nope.
Okay. And Your Honor, as to the felony case, that is case number 25CF626, in which the court has just found her competent to proceed. The agreement in that case is that she'll plead no contest as charged. It'll be a withhold of adjudication, 2 years of probation, with the only special condition being that she serve 11 months and 29 days in the county jail. She'll get credit for all time served. And just to make sure we don't have any issues, that does include any time spent in the Florida State Hospital. Probation will automatically terminate upon release from jail. She will need to pay $515 in court costs and $150 cost of defense. And we would ask the court provide her with 1 year to make those payments. I have no objection to the score sheet.
State's agreement?
State's agreement, Your Honor.
All right, you may approach.
Thank you.
All right,
And we
Ms.
did fill out the score sheet. That's that Mr. Gomez and I could put our heads together and do because of the sentence being the probation with the county jail.
Okay. That works. Raise your right hand for me, please, Ms. McNamara. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
Okay, you can put your hand down. You heard what Ms. Jaquith said, and you signed the 2 separate written pleas.
I did.
All right. So we're going to talk about the misdemeanor plea really quickly, which I'm taking as a convenience to the county judge in this matter, just so that you'll have only 1 court appearance instead of having to have 2.
Thank
Do you understand by this plea arrangement that you're pleading no contest? Well, first, I'm going to allow you to withdraw your prior plea, and you're now pleading no contest to the petty theft case and waiving your right to a trial by jury. Did you understand that?
I do.
And the sentence in this case is going to be
It's on the very last page, Your Honor.
Yeah.
I know that plea agreement is,
you'll be adjudicated guilty, 60 days in the county jail, credit for the time served, and the state stipulates you have that credit, and you'll have your fees and costs that were announced, and the payment of restitution, and all that'll be due 120 days after your release. Is that what you understood?
I do.
Ms. Jaquith answered all your questions about the plea and how it
Yes, she
affects you.
has.
You satisfied with what she's done?
I am.
All right.
Very.
The court will find the plea in 25 MM 1401 taken as a convenience to the county judge, freely and voluntarily entered into. All right, now, as to the felony case, did you read and understand the plea form before you
I
signed
did.
it? And how old are you?
How old am I?
Yes.
I'm 60.
Okay, and how much schooling do you have?
College.
Okay, you able to read and understand the plea form?
Yes, I did.
And you do that before you signed it?
I did.
And what you read in there is what Ms. Jaquith announced?
Absolutely.
And you understand that you're pleading no contest to the announced charges in this case?
I do.
And that tells me you believe the state could prove your guilt and you're not going to contest that.
Absolutely.
And by doing this, you understand you're waiving your right to a trial where the state would have to prove your guilt.
I do.
And in this case, adjudication will be withheld. You're going to be on 2 years of probation with the condition of the 11 months, 29 days in the county jail, which is stipulated that you have already served that time. And your probation terminates upon your release from jail with the fees and costs. And how much time to pay those?
a year, please, Your Honor.
Okay. Okay. And once again, Ms. Jaquith answered all your questions about this plea and how it affects you.
Yes.
And are you satisfied with what she's done for you?
Yes. Very.
All right. The court will find the plea to be in 25 CF 626 to be freely and voluntarily entered into and accept the plea.
Thank you, Your Honor. And just for the record, I did discuss with Ms. McNamara, I know she had written several letters to the court. I did discuss with her those letters and the things that she had mentioned in those. Bless you.
Excuse me.
And her option to have a Nelson hearing, should she feel that was necessary. And in speaking with her, she indicated that she was just frustrated with the delay for the hospital and that she did not feel the need for a Nelson hearing. So I just want to make a clear record of that was discussed.
All right. Thank you very much.
Thank you, Your Honor.
Thank you. Good day.
Yep.
Okay. Thank you, Mr. Gomez.
Jason McKinney on behalf of Mary Guthrie, 21 CF 2550. This is a violation of probation. We've reached an agreement. Ms. Guthrie is going to admit the violation of probation. We're going to reinstate supervision to complete the original requirements. Part of those original requirements includes GPS that must be attached before her release, $100 BOP fee, and $150 cost of defense. May I approach with that plea agreement?
Yes.
I do want to make the record that one of the original conditions is also a suspended sentence. That is still sitting there.
And she was previously adjudicated,
Correct.
correct? All right. Is this the state's agreement?
It is, Your Honor.
All right, raise your right hand, please. Do you, other one?
Sorry.
That's all right. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
Okay, and you put your hand down. You heard what Mr. McKinney said, and you signed the written plea form?
Yes, sir.
You understand you're admitting the violation?
Yes, sir.
And that tells me that you agree with your probation officer's report about how you violated.
Yes, sir.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove the violation?
Yes, sir.
And you'll be reinstated to complete your original conditions, GPS before your release, and then you'll have the additional fees and costs.
Yes,
Now,
sir.
Mr. McKinney was very careful to announce that this reinstatement includes the potential for your suspended sentence.
Correct.
And the reason he mentioned that is because ordinarily, suspended sentences are imposed for a reason.
Correct.
Now, the state's been, extended you a good result by allowing you to reinstate without imposing the suspended sentence.
Yes, sir.
Please understand that it's not a hard and fast rule, but as a general rule, if there's a suspended sentence and you violate and it's a contested matter, then this court will impose the suspended sentence. The purpose of it is to be certain that you understand that a violation will result in the imposition of the suspended sentence. That's its purpose.
Yes, sir.
So that's the reason Mr. McKinney specifically pointed that out, so that you would know and understand that.
Yes, sir.
Understand?
Yes, sir.
So, all right, thank you very much.
Thank you. God bless.
The court finds the plea to be freely and voluntarily entered into and accepts the plea.
Deja Terry?
Judge, may I have just a moment?
Yes, sir.
And Ms. Terry is here in 25 CF 2186. I was a little bit confused when I looked at the docket because it said that there was a signature bond in this matter, but she's obviously in jail. I would enter a denial to the arraignment for the violation of probation today and ask for the next available without subpoenas, so that I have an opportunity to go through things in more detail with Ms. Terry.
All right. Is there an offer?
The offer that's been communicated by the state is 6 months in the Okaloosa County Jail with an adjudication of guilt, and that will revoke and terminate her supervision. Is that accurate statement?
That's correct. I mean, that's, yeah. That's what I,
Okay. And set it for 5:14. 9 o'clock?
Yes, Judge.
Okay. Very good.
The underlying misdemeanor that's the basis for the violation has already been pled. So I do want a chance to discuss that further with Ms. Terry and talk to the state.
All right, very good. Thank you.
Adrian Sanders? Yep.
Your Honor, I just, about 5 minutes ago, worked out both Mr. Sanders' misdemeanor and felony case. If I can just, I'm hoping the court will agree to take a plea without a written plea agreement based on the fact that it would just happen this morning. And it is beneficial to Mr. Sanders and what Mr. Sanders and I discussed. If I may just explain to him the situation. And Your Honor, I did email Madam Clerk, so she had this information, and I also spoke with probation to explain to them what we were planning to do. And I would ask that the court take a plea on 26 MM 748 as a convenience to the supervising misdemeanor judge.
I'm uncomfortable doing that because of the problems we had with the clerk not having the written plea. Now, if you want to do it and email it to Ms. Natalia, I'll ask her to print it for you so we can do it, and then we can hold Mr. Sanders until you can get that done.
I can try.
You understand my problem with what has been happening in the background, and just be sure that, and this is not about you, this is about the process. I'm going to be clear, this is not about you. That's my only concern, Ms. Jaquith.
You want to write it, or you want?
Do you have a written plea agreement? Your Honor, if you will just, if we can pass Mr. Sanders for a few minutes, Mr. McKinney's offering me a plea agreement, and I can handwrite everything out so that we have everything in writing.
Perfect, that way there'll be, because what I don't want to do is end up in the loop we had with a couple of those defendants where it ended up creating an adverse consequence, and I don't want that.
And I would have much rather done it in writing. Unfortunately, Mr. Snell and I have been rushing to get it done, so.
I don't care about the consequence for me, but I care about the consequence for a defendant if I don't do it right.
Absolutely.
Okay, all right, so if you'll hold Mr. Sanders so that Ms. Jaquith can bring him back, okay, very good.
Matthew Matecki.
Your Honor, I thought they were going straight down the order, so I'm sorry. This is Mr. Watucky before the court, Matthew Watucky in 24 CF 2710.
Yes,
Can Mr. Snell and I approach on Mr. Watucky's case?
granted.
Your Honor, is to 24 CF 2710, Mr. Witucky. Based on the conversation we had at the bench and the conversation I had with Mr. Witucky, I'd asked to continue this to May 14th at 9 a.m. And then I will talk to Mr. Snell either tomorrow or the beginning of next week, and we will get a set in stone resolution and how we'd like to do things, and then I will make sure that we get the appropriate motions and orders over to the court.
Careful how you use that now.
I will get a written agreement.
Mr. Witucky got it, it took you a second. You
I will get-
understand what we're trying to accomplish, Mr. Witucky, and I thank you for the progress you've made, and we'll try to do what we can to accomplish the goal that your attorney has set out and the estate's agreement is, and we'll try our best to get that accomplished after you work your deal out in Walton County, okay? Okay. And whatever they can work out, I'll try to work with them to be sure that that happens for you.
And with all the kind of gymnastics we'll need to do, we're doing with this particular situation, I can see the confusion in Mr. Witucky's face when I'm explaining it to him. And so I told him as soon as I speak to Mr. Sell and get that guaranteed agreement, that I will come out and explain everything to him and see what his wishes are and see how he wishes to resolve. And then we can go from there.
Okay, very good.
Thank you, Your Honor.
See you then, sir.
Randy Williams.
Judge, this is Mr. Randy Williams approaching the court. Back on the date again? I was just inquiring as to why he was in a boot again, because I know he had leg surgery. He's here in 24 CF 2057, 24 CF 2508, and 24 CF 2707. I am not privately retained in the 2707 case, even though that's what it shows in the docket. So I just wanted to make a record that I am his attorney in all three of those cases as a public defender. He was previously in Phoenix House. We're waiting on the director's approval to see if that's going to open that door again. He was medically discharged. That's not part of the violation of probation, but whether or not we can get him back in that program impacts the discussions with the state, with Mr. Snell. So I do not have that answer back from the director of Phoenix House as of yet. So I'm going to request a continuance to the next available miscellaneous date without subpoenas. And hopefully this is a position that we can get an answer sooner than that and put it back on an earlier docket.
State.
No objection.
So,
I'm sorry, I interrupted you.
no, it's okay. So we want to do the second date in June just to give you enough time, and then if he comes through, I don't want to just transport him, particularly if
That's
he's
fine.
struggling with his foot.
I know, let's put it on the second date in June date with the expectation that it's not going to take that long. I know we were hoping to have an answer by today from Phoenix House. I reached out yesterday, and we still have to have.
Would you, I don't want to push it off and to have to reset it. You think we can do it by the 14th?
We should have an answer shortly.
Okay,
So
well then
I-
just
I-
put it on 5/14.
I think we should have an answer for sure on that. I was, like I said, I was expecting to have that answer by today,
Okay.
because all the paperwork is done, we're just waiting on official answers.
We'll put it on 5/14. If it comes in before then you know I'll take a plea whenever I'm here.
Yes, sir.
Okay.
Thank you, Your Honor.
Thank you now. Good day.
Marlis Brown. Mr. Brown.
Morning, Your Honor. Attorney Chris Cochran on behalf of Marlos Brown, case number 21 CF 2753. Your Honor, this morning my client will be entering a plea where we will admit the violation, and in exchange for the admission, the state has agreed to revoke and terminate the probation, a sentence of 46.95 months Department of Correction. He will receive any credit that he has, court costs, and cost of defense. If I have one moment for my client to sign.
Yes.
sheet. And just for the record, my client will be getting credit for the prior VOC findings.
All right. So it's a straight revoke and terminate,
Yes, Your Honor.
and the sentence, and is there an agreement on how much time there is? Is this not a time served, is it?
Yeah, I believe it may be a time served, Your Honor.
Well, please approach.
You're ready, Your Honor.
All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. Now, you heard what Mr. Cochran said, and you signed the written plea form.
Yes, sir.
You understand that you're admitting the violation.
Yes, sir.
That says to me you agree with your officer who says that you violated your probation.
Yes, sir.
And by doing this, do you understand that you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
In this case, you were previously adjudicated guilty in this case, and the sentence is going to be a revoke and terminate your probation with $100 cost of prosecution, $150 cost of state-provided legal assistance, plus whatever outstanding costs you have. How much time do you think you'll need? Is 24 months enough to get that paid
How much
after?
is it, Your Honor?
Say again?
How much is it altogether?
I don't know. I looked this morning, but I can't see all your totals. I don't know.
Man, I'll start working on it as soon as possible.
Okay, 24 months to pay, and that'll give you a chance to really get on your feet. And the
sir.
sentence in this case is 46.95 months, Department of Corrections, and the state, credit for all time served, and the state stipulates that you have the full amount of the credit, so you've essentially, this is a time served sentence.
Yes, sir.
Has Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
You satisfied with how he's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea with the adjudication. Thank you. Okay, hold on just a second, Mr. Cochran. Mr. Gomez, Madam Clerk, go ahead.
Showing that he's on count 4 for this, he already served for counts 1 and 3 in the EOC. So is this just for count 4?
She said what?
Did. I don't think so. probably was too. That's what his paperwork said.
That's David only goes to count four. When he was originally sentenced, he was sentenced to 46.9 minus counts 1 through 3, and then probation for count 4.
All right, so,
Hold on now, I'm trying to figure this out now. Yes, Your Honor, we would just say that would only apply to count 4. Might have to redraft the.
so,
You may have to redraft the form.
because originally we had 1, 2, 3, 4, 5, 6, 7, 8, 9 counts, right? And it looks like 6, 7, 8, and 9, there's no disposition, so I'm just guessing that they were null pros. Is that what it was, Madam Clerk? No information, so those are the original charges. And then I have 1, 2, 3, 4, and 5, where he pled. And then let's look and see where we are. All right, and so the plea agreement says 1 through 3, and so the count 5 is clearly termed. Yeah, it looks like it's only count 4, which was originally 36 months DOC, followed by the probation.
That's correct, Your Honor. Doesn't change the outcome, we still.
All right, so this, then I'm just going to say, I'm just going to strike through 1, 2, and 3 on the plea form and say, I'm just going to strike through that. Does everybody agree to that?
Yeah, sure.
Because then looking at the violation does, okay. It does not change the disposition. Thank you, Madam Clerk. All right.
still okay.
Thank you.
Eddie Lanu.
Correct. Yeah, and so we'd have to do it over. Better to do it right than do it over.
One moment.
Your Honor, Mr. Cochran, on behalf of Teddy Lanu, case number 25 CF 1373. Your Honor, today we're going to enter a denial of the violation and ask for the next court date without subpoena.
All right, is there an offer?
Yes, Your Honor, it was 16.35 months in the Department of Corrections, the guideline sentence.
All right, so how quickly? 514, no subs? Is that too quick?
No, that's perfect.
514, no subs.
I was supposed to be taking the violation for not checking in, not for not completing my community service.
Next is Eddie Lewis.
Lewis?
I have one moment, Your Honor.
Yes, sir.
Your Honor, my client would like me to clarify, if he were to take a plea today, he would get credit for all the time he's previously served on this charge.
Is there any issue with
There would
credit for all time served?
There would be no objection to credit for all time that they're legally entitled to, Your Honor.
Okay. Your Honor, this is going to be a plea. If I can have him come back out in a few minutes.
Absolutely.
I'll get the paperwork out of the way.
Hold Mr. Lewis for a plea.
No, you go and come back.
Livingston?
One second, Your Honor.
Yes, sir.
Your Honor, we have Mr. Daniel Livingston, case number 25 CF 0520. Mr. Livingston has just returned from Florida State Hospital, has been restored as competent, and he is ready to enter a plea today. In exchange for a plea of no contest, the state has agreed to a lesser included offense of criminal mischief under $1,000, statute 806.131 Bravo 2. And it'll be an adjudication, credit time served, court costs, cost of defense, and cost of prosecution. If I may approach, Your Honor, I have to sign a plea form.
Granted. State stipulate to the report.
State stipulation, Your Honor. And that is the agreement between the state and the defense.
Court finds the defendant able to proceed. Raise your right hand, please. You swear affirm to testify truthfully in this matter under penalties of perjury.
Yes, sir.
Okay, you can put your hand down. You heard what Mr. Cochran said and you signed the written plea form.
Yes, sir.
Do you understand you're pleading no contest to the lesser included offense,
Yes, sir.
waiving your right to a trial by jury?
Yes, sir.
You'll be adjudicated guilty, be sentenced to time served with the fees and cost, and those would be, Madam Clerk?
$207 court costs, $150.
Good.
All right, and I'll give you a year to pay those, okay?
Negative needs to be redrawn. They're gonna write down these changes.
All right. Mr. Cochran answered all your questions about the plea. Do you need a minute with your lawyer, sir?
We're just talking about the financials, Your Honor, real quick.
Okay.
Total, Your Honor?
270 plus the 150 plus the 1,000? Where's the 1,000 coming?
No, it said, is it roughly 1,000 total?
It's less than that.
Oh, it's less than that, okay.
Yeah, it's
a year. Sorry.
$450, something like that.
Yes, sir.
Okay, so a year to pay. Mr. Cochran answered all your questions about the plea and how it affects you.
Yes, Your Honor.
Satisfied what he's done for you.
Yes, sir, absolutely.
Court finds the plea to be freely and voluntarily entered into and accepts the plea. Thank you.
Thank you.
Recall Adrian Saunders.
Saunders, please.
Mr. Saunders.
Your Honor, if I may just pause for a moment and have Mr. Sanders sign the agreement.
Yes, ma'am.
Okay, Your Honor, so back with Mr. Sanders, as to his two probation cases, 23 CF 1862 and 24 CF 348, he will admit the violation, be reinstated to probation. The cost of supervision will be waived, both the future and prior, so all rearages will also be waived. $200 cost, VOP cost of prosecution, $250 cost of defense since there's two cases. Probation may terminate upon completion of the outstanding community service hours. That's the only thing he has outstanding, other than costs. And if there are still outstanding costs, once he completes those community service hours, those may automatically go to civil lien without the need for another waiver. He is nearing the end of his probation sentence. This is essentially why we're structuring it this way. Your Honor, 26 MM 748 is a misdemeanor case we're asking the court to take as a convenience to the supervising misdemeanor judge. He'll be pleading to a lesser included offense of disorderly conduct, statute 877.03. As to that charge, he will plead no contest, be adjudicated guilty, sentenced to 30 days in the county jail with credit for time served, $270 in court costs, and a $50 cost of defense. And we have no objection to the score sheet. May I approach? Oh, and this is a downward departure based on a legitimate uncoerced plea. May I approach?
Granted. Raise your right hand, Ms. Sanders. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, now you can put your hand down. You heard what Ms. Jaquith said and you signed the written plea form.
Yes, sir.
You got two different things going on today, but we're taking care of them in one plea. You understand that?
Yes, sir.
All right, as to the felony VOP, you understand that you're admitting the violation.
Yes, sir.
And that tells me that you agree with your probation officer, how they wrote down you violated your probation report.
Yes, sir.
And you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
As to your misdemeanor, do you understand you're pleading no contest and waiving your right to a trial by jury?
Yes, sir.
All right. And that's to the lesser included disorderly conduct charge. And as to your violation, you'll be reinstated your probation. We'll waive the cost of supervision, future and prior. You'll have the fees and costs that were announced. And your probation can terminate upon the completion of your community service hours. And essentially, we're structuring this to require you to get your community service hours done, but at the same time, allowing you to terminate your probation without the completion of the payment of your costs.
Yes, sir.
Now, if you do that and you don't pay your costs, then they're going to go to a judgment, and that judgment may have consequences for you later on in other ways. So if, when you reach that point, you want time to pay those fees and costs, then Ms. Jaquith can tell you what you need to do to ask me to give you time, and I'll do that. And as long as you're making payments, I'll continue to give you time. But if you're not making payments, don't ask for more time. You
No,
got
I
it?
understand. Yes, sir.
All right. But my goal here is I don't want the collection of the fees and costs to have adverse consequences, which would then not, which would set you up for failure. So if you're making payments, I'll help you, set yourself up for success. If you're not making payments, then I won't. Does that make
Okay, I
sense?
appreciate that, sir.
Okay. And then as to the misdemeanor, you've got time served on that. 30 days county jail, credit for time served, and then you got the fees and costs, which are the $270 and the cost of defense, and I'll give you a year to get those paid, okay?
Okay, thank you, sir.
All right. Ms. Jaquith answered all your questions about the plea and how it affects you.
Yes, sir.
Satisfied with what she's done for you.
Yes, sir.
The court will find the plea freely and voluntarily entered into, and will accept the plea in the misdemeanor case as a convenience to the supervising county judge.
Thank you, Your Honor.
Thank you.
Antoine McCray.
Today, go at 8 a.m. tomorrow.
Thank you, Your Honor. Excuse me, that's all I have on today's document. May I excuse?
Madam Clerk, can you confirm that's everything for Ms. Jaquith?
Thank you.
Good day, ma'am.
Thank you, Your Honor.
Mr. Cochran, on behalf of Anton McQuay, 24 CF 1314, Your Honor, we're going to enter a plea today. In exchange for admitting the violation of probation, the state has agreed to term and revoke with 9 months Okaloosa County Jail with credit for a previous time served, court costs, cost of defense, and cost of prosecution. I have one moment to have my client sign.
Yes, sir.
You want to just do the minors and then take him out?
Mr. Cotton, are you,
I'm ready whenever the court's ready. I think we've got an agreement, Judge.
okay, so
And that's for Mr. Thompson.
Thompson, correct. So you just line them up until we get, we'll get Mr. Stewart's client as soon as he's convenient for transport.
Hey, Frank, can you put Kenneth Thompson, number 29 in the...
Your Honor, I have the signed forms if I may approach.
Granted.
Mr. Cotton has a deal.
Thank you.
She is also there.
All right. Good morning. Go ahead.
No, he's going to admit the violation. In exchange, it will be 9 months of Okaloosa County Jail with credit for any time he's already served, court costs, cost of prosecution, and cost of defense.
Okay. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. Now, you heard what Mr. Cochran said, and you signed the written plea form.
Yes, sir.
You understand you're admitting the violation.
Yes, sir.
And that says to me you agree with your probation officer of how you violated your probation.
Yes, sir.
You understand by doing this, you're waiving the right to a hearing where the state would have to prove that violation.
Yes, sir.
And you were previously adjudicated guilty. Your probation can be revoked and terminated. You're sentenced to 90 days in county jail, credit for all time served. You have $100 cost of prosecution, $150 state-provided legal assistance, and is a year enough time for you to get your all your fees and costs paid after your release?
Yes, sir.
Okay.
And Your Honor, there was a misspoke, you said 90 days, it's 9 months.
9 months, I apologize, 9 months in the county jail. Credit for all time served.
Yes, sir.
And Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
Satisfied what he's done for you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you, sir. Mr. Myers?
Myers, please.
Your Honor, next we have Mr. Jason Myers, case number 26 CF 125. Your Honor, there is a report finding Mr. Myers incompetent. I believe the state can stipulate that report.
State will stipulate, Your Honor.
With Florida State Hospital, I can do the order and send it over to the clerks, or to the chambers. Your Honor.
All right, the court finds the defendant is not able to proceed based upon the stipulation of the state to the report, and the court will commit the defendant to the custody of the Department of Children and Families.
Thank you, Your Honor. I'll send it forward. Order in order.
And Madam Clerk, let's set a status date in 6 months. What date would that be?
October
8/16. And that's status only, the defendant does not need to be transported. I'm just trying to do this based upon the problems we've had in the past with these
I just want to make sure it's 10/16, right?
10/16.
Or 10/15?
Okay.
We've got a lot of numbers mixed up. Okay.
No, it's 10:44. Okay, 10:15. I don't know where I got that.
And I believe that concludes my business today, Your Honor. Madam Clerk.
Are you doing any of this?
Oh, yeah, we're still going to do Eddie Lewis. I'm sorry. I do have one left.
All right.
You can't go yet.
Holly Martin? Mr. Stewart? Holly Martin?
Mr. Stewart, we have your client now.
Thank you, Judge. For the record, Brad Stewart on behalf of Holly Martin. Judge, this is 25 CF 1019 and 1029. I've got the order of appointments within the last 48 hours. I think we filed on it late yesterday.
Yes.
I have very little knowledge of Ms. Martin's case at this point. We're waiting on discovery, so we do need to move that over, Judge. I think our pretrial conference date is 5/11. If we want to move it there, I'll give you an opportunity to get with Mr. Gomez on the matter.
So leave it on for 5/11, Mr. Gomez?
I would-
Is it-
Yes, sir.
No objection from the state, Your Honor.
All right, so Ms. Martin, get in touch with Mr. Stewart so that he can have access to you to help you move your case forward, okay?
Thank you so much.
All right, and see you on 5/11.
Thank you.
Ms. Martin, if you'll call my office, please, when you leave the courthouse, okay?
Okay, thank you.
Thank you, Mr.
All right.
Stewart. Thank you, Mr. Stewart.
Thank you, Your Honor. That's all I have. Maybe issues?
Yes, sir, good day.
Keon
Thank you.
Thompson?
Classic then, excuse me.
Yes, sir.
Till they make these phones in Braille.
Got somebody in the.
Your Honor, we're on your 12:30 docket, and we're trying to resolve this morning. This is State of Florida v. Knopf Thompson. Judge, pardon me, and I'll pull that case number for you.
It's 26 CF 755.
Thank you, Your Honor. Your Honor, in this case, this is set for a pretrial detention hearing mandated by statute. The state has reviewed this case, and I believe we've stipulated to a bond with conditions, if I could announce those.
Yes, sir.
Your Honor, pursuant to an agreement with the state, I believe the bond would be, there's 2 counts. On the first count, I believe it's a home invasion robbery charge. That would be $20,000, cash or professional.
We were advised he was not.
There's count 2 is an aggravated battery. The instrumentality, deadly weapon in this case would have been a car. Is $5,000 cash or professional. Special conditions of pretrial release would be that he report to pretrial services, pretrial release services 1 time per week. He's allowed to do that by phone. He lives in Pensacola. The defendant does. He not contact the alleged victim in the case, whose name is, do we say that out loud, or you need me to approach with that, Judge? I know it. Okay. Kawana Gamble, and not go within 500 foot of the residence. I do not have that information. That's not my case, but I like that. What is it? 318 Maurice Circle, Northwest. And that's in Fort Walton Beach.
All right,
Those would be all the terms and conditions of the release and supervision.
all right.
That's the state's, yes, sir.
Who's going to do the order since ordinarily I would have the order, but since that's 12:30, I don't have them with me.
Judge, if it's okay, I'll just go back to my office, prepare that, send it over, and copy the state on it. It'll reflect
All
exactly
right,
what
and then I'll take care of doing the order that the state's not proceeding on the pretrial detention.
Perfect. And I'll set the bond conditions in the order. Do you need me to file a separate motion, Judge, or can I just do an order granting?
No, because we're here on the pretrial detention, you have agreed to the bond, so you just put that in that the state did not proceed on pretrial detention and set the bond conditions as follows.
Perfect. I will, I'll have that to you within the hour.
All right, and be sure you include pretrial on the service list on the bottom. That way, Madam Clerk, and they'll,
Do you by any chance have their email up there somewhere on one of those documents that I could grab? If not, I'll run it down.
Miss Natalie can provide it to you.
Actually, I've got one in mind.
And so, and they'll come and talk to you before you release and give you your instructions, so the jail's not going to let you out until pretrial comes and chats with you to give you instructions to you processing. And which is going to be better for him reporting is by phone on occasion. Now, if requested, he's going to have to report in person. That's part of the
follow any
requirement.
instructions.
So would that be Crestview or Fort Walton be better for him?
Crestview, Fort Walton, easier for you to get to if you had to report. If you had to. Okay.
What's your choice? You
I'll take Crestview far away from.
Well, just to stay.
Yeah, stay out of Fort Walton.
Okay, Crestview reporting. I just want to make it the easiest possible for you.
I did hear a client tell me the other day, even though it said report by phone, they were asking them to come over once a month or something.
Right. Well, they have the choice to, at any time, require them to appear in person. Okay. All right, very good.
All right, that's all I've got. I'll get that order to you here shortly.
Very good, thank you.
Mr. Cotton, that email will be on this too.
Thank you very much, Madam Clerk. Judge, that's all I have. Maybe excuse
Thank you,
me.
Mr.
Thank
Cotton.
you
I
for taking
appreciate
the
your
order.
patience, and we take care of this now. It's 10 minutes to 11. I'm going to take just a 5-minute comfort break here at this point, okay? 5 minutes.
All rise, please. Circuit Court is in a 5-minute break.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Something to do with first appearance in your office call about these cases on your behalf. All right, please be seated.
Your Honor, may I call a case from the gallery?
Yes, ma'am.
Mr. Snell? Yes. Your Honor, actually,
What's happening now?
just,
Good.
okay. We are ready to proceed. This is Russell Snell III before the court in 25 CF 1489. Your Honor, in this case, we have worked out an agreement to resolve with mental health court. So if we could continue this case at this point, and then we hope for a plea in mental health court at the next date, which is next Wednesday.
That's correct.
So we're simply saying this going to mental health court. Should we set it for status on 5/18 to be sure that nothing happens?
Yes, if we could.
Okay.
5/18 or 5/14?
5/14, sorry. All right. All right, very good. Thank you.
Recall, Eddie Lewis.
Lewis, please.
So it was just, they didn't do the probation. They didn't wait.
Frank.
Your Honor, we have Mr. Eddie Lewis, case number 24 CF 2716. Your Honor, we're enter a plea this morning. In exchange for an admission of the violation, the state has agreed to term and revoke the probation 1129 in the Okaloosa County Jail with credit for any time he has already served, court costs, cost of defense, and cost of prosecution. On the approach, I have the score sheet.
And Your Honor, this is a downward departure for the purposes of a legitimate unenforced plea.
Have the score sheet, the plea form on the approach.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? Okay, and you put your hand down. You heard what Mr. Cochran said and you signed the written plea form?
Yeah.
Do you understand you're admitting the violation?
Yes, sir.
And that tells me you agree with what your probation officer says about how you violated your probation.
Yes, sir.
Do you understand by doing this, you are waiving your right to a hearing where the state would have to prove your violation?
This is something about. That's cool.
Say again?
Yeah.
Okay. Yeah, so you're admitting the violation, and by doing that, you won't have a hearing where the state would have to prove it. That's the question. You understand that?
I understand.
Okay. And in this case, you will be adjudicated guilty. Your probation will be revoked and terminated. You'll be sentenced to the 1129 in the county jail with all credit for time served granted. You'll have $100 cost of prosecution, $150 state-provided legal assistance, and whatever outstanding fees and costs you have. You think a year will be enough time for you to get those things paid after you get released? Okay, a year to pay. And Mr. Cochran answered all your questions about the plea and how it affects you.
Yes. I won't.
There is one question, Your Honor. He wants to make sure that none of his previous credit time was waived. When I entered his plea Last year, I did not waive any credit time.
That's correct, and the state stipulates that he does not waive any of his credit time. He's entitled to all of the credit that he's already served.
And I'll just put on here,
So the court's gonna say. That way they can have a bond hearing and say, you stipulated to have it at that hearing. Does that make sense?
I put on here, there is no prior waiver of credit for time served. The defendant gets all credit for time served. Okay?
Thank you, guys.
All right. And so Mr. Cochran answered all your questions?
Yes, sir.
Satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Yeah, I appreciate it.
Christopher Carpenter.
Thank you.
Now I believe that concludes my business.
All right. What are we looking for on Rodriguez? Is that going to be a, no, I'm sorry, shifting gears, is that going to be a hearing?
Which one? Rodriguez. Yeah, we're just discussing that.
Okay.
Yes.
All right. I'm just trying to do a little advanced planning.
Sure, John. Well, I want to talk to the victim.
Okay.
If you, that just.
Judge, this is Christopher Carpenter before the court in 16 CF 1849. And the position of this case is Mr. Carpenter is deciding whether or not he wishes to push forward towards an evidentiary hearing or accept an offer from the state. The state's offer, as stated in court last time, and I believe again today, is 15 years Department of Corrections to revoke and terminate. He does have a prior 10-year sentence that would be included in that credit. Primarily putting those things on the record. I've discussed it fully with Mr. Carpenter at the jail. We took extra time and moved it to the day to have some additional discussions. In talking to Mr. Carpenter, he did inform me that he had filed a petition asking the court for a Nelson hearing. I don't believe that's made it to the progress docket at this point. And I don't believe that that's his intention, that he wishes to actually proceed forward with that. But because I heard that from a client, I wanted to make sure the court was aware to ask Mr. Carpenter about that.
All right, raise your right hand for me, please, Mr.
Yes, sir.
Carpenter. You swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you can put your hand down.
Yes, sir, Your Honor.
You just heard what Mr. McKinney said about a correspondence which seemed to say you wish the court to address issues regarding Mr. McKinney's representation. Do you wish to go forward with that?
No, sir, Your Honor. After we discussed yesterday and then today, I was trying to hold off till I talked to him, Your Honor. And also I drafted a motion. I talked to him about it yesterday, but I didn't have it done. That I was presenting to him today. And we talked about it to see possibly him adopting it, you know, if he feels that it would, if I have the grounds for it. If not, then we're going to further discuss on what my other options would be, Your Honor. Because I do know when we first had this happen back in November, before I was transported down here, I tried filing a motion to dismiss, but my options that I had for stuff up there was limited, and I know it was wrong, so.
Okay.
He's only asking
Okay.
related to the Nelson
Yes.
hearing right now.
Sorry, Your Honor.
Okay, I'm sorry. That's okay.
And so I'm just reading the VOP report, which alleges that he was being supervised in a sister state under ICOTS, and that's a violation of one of and the allegation is that it was a violation of contact with a minor, which is prohibited under the terms of the probation order. That's the substantive violation alleged.
Correct. I would
Okay.
agree that that is the allegation in the VOP report.
All right. And it appears that there are a number of different pro se or self-represented communications that the defendant had with the court prior to him arriving here, which are in the progress docket, which you've had the benefit of, Mr.
Yes,
McKinney.
Judge.
But it looks like the defendant has been here since maybe 12/31 or
December 23rd.
24 December, so.
Yes, sir, Your Honor. I believe that's what it was.
Yeah, it's, so shouldn't we just go ahead and set this for VOP evidentiary and with subs? And I guess that's going to require some extended time for the state to coordinate their witnesses from the sister state, correct?
And that was the intention of the defense, to set that for a hearing. I was going to ask for the 6/18 date.
Okay.
To give us some additional time to do that. And I did want to make a clear record that Mr. Carpenter didn't wish to proceed forward with a Nelson inquiry.
Yes, that was my understanding.
Yes, that's correct, Your Honor.
All right.
And then I am aware of some of the issues that Mr. Carpenter wishes for me to raise. I told him that I would happily read that through and discuss that further with him. But I do think it's appropriate at this time to make a record that he is rejecting the state's offer, and that he, at this point, we would be setting a hearing with subpoenas. And as stated, I would ask for the June 18th date, so that we have time to put some of those moving pieces together, as some of them are going to be out of state.
All right, 6/18 with subs, you can collaborate with the state regarding appearances and so on.
And related to appearances via Zoom for contested hearings, does the court take a position or rely upon the attorneys to file the appropriate motions?
The rule requires a motion. However, you know this court's position: if the state and the defense agree, an announcement in open court is sufficient for the court to discharge. I don't believe in busy work. So if y'all announce in open court that that's satisfactory, then we have a record of it, and I'm okay with that. If there are contested issues, then file your motion, and I'll rule accordingly.
Given the nature of some of the witnesses, is the only reason why I bring that up ahead of time.
Mm-hmm.
Do you have any questions about what I just said?
No, sir.
Okay.
Okay, thank you, Judge.
Thank you.
Jack Hill.
Mr. Jack Hill is approaching at 12 CF 312. This is a VOP arraignment. I would enter a denial and ask for this to be set without subpoenas on the next available date. I would like an opportunity to speak with Ms. Leone regarding the violation in this matter, to see if we can negotiate.
And I'm sorry, Mr. McKinney, you got ahead of me. Which defendant is this?
This is Jack Hill.
Hill. Okay.
Mr. Hill is here in 12 CF 312.
Okay. And without subpoenas, the first date?
Correct.
In June, you say?
No, I can have the next available, which is
5/14.
5/14, if we could have
No
that date.
subs.
If we're unable to reach an agreement on that date, then we would likely set it on a hearing date from there.
Is there an offer?
Judge, I know that this is new to me and Ms. Leone, so I'd like a chance to discuss it through. I don't know if there's an offer for today.
No, Your Honor, I haven't had the chance to review it. I wasn't aware of this case yet.
Okay. All right. We'll see on 5/14. And once again, if you reach a resolution sooner, any day I'm here, I'll take it.
Yes, sir.
Dejan Kimbrough.
This is Mr. Dijon Kimbrough. He's here in 17 CF 3377. We're ready, Judge. I just wanted to confirm. The state had made an offer to Mr. Kimbrough of 13 years to the Department of Corrections to revoke and terminate. I would note that previously, when Mr. Kimbrough, you might need to grab the file, make sure that I get the numbers correctly. And if I skip straight to the end, we're going to be asking the court to set a hearing with subpoenas on 6/11 so that we have an opportunity to get some additional records from REAP. When Mr. Kimbrough was first placed on supervision, this was a plea, open plea to the court with a sentencing cap of 7.975 years with credit for time served, no cap on probation. The court sentenced to 5 years probation. I make that record to make sure that everybody's on the same page and that that cap doesn't apply in a violation of probation. So I believe that count 1 is a life felony, count 2 is a first-degree felony, and those maximums would apply in any pleas to the bench or sentencing after a contested sentencing hearing. I would ask that we go ahead at this point, since I believe Mr. Kimbrough is rejecting the state's offer of 13 years department, to go ahead and set this as a contested sentence or a contested evidentiary hearing on the 11th of June in the afternoon.
All right, 6/11 with subs at 2 p.m.
Any questions?
Thomas Cole.
If not changes, then I certainly will. Judge, may I have just a moment?
Yes, sir.
Judge, this is Mr. Thomas Cole. Mr. Cole is before the court in 23 CF 851. I would note for the record that there is a 10-year suspended sentence on 23 CF 851. And in speaking with the state, is the state in a position to agree to reinstate the supervision for Mr. Cole, or is the state seeking the imposition of a suspended sentence? I believe the last discussion with the state was that they were seeking the imposition of the suspended sentence.
It is, Your Honor.
So, hearing the option that we have. Judge, I believe this is going to turn into a plea to the bench and set off for sentencing. I'd like an opportunity for him to read a plea agreement. Before doing that, if we could call him back.
All right, let's hold him for a plea.
Yes, Your Honor. Stephen Pancos will be next. Frank, we need Thomas Cole back.
This is Stephen Pancos before the court in 25 CF 2136. We've come to a resolution in this case. The terms will be an adjudication of guilt, plead no contest as charged, 5 years of standard probation, complete the Phoenix House program, $4,200 in restitution to the Take 5, no trespassing at Take 5 on 760 Beale Parkway in Fort Walton Beach, 48 hours of community service, random urinalysis and breath tests, court costs, and cost of defense.
Your Honor, this is a downward departure for the purposes of a legitimate uncoerced plea bargain and that the needs for restitution outweigh the need for a prison sentence.
And additionally, we would ask the court to waive the cost of supervision.
And this is a Phoenix House plea?
Yes.
May I approach, Judge?
Granted. And Mr. Pancos, that wasn't about you individually, it was about some information that Mr. McKinney was sharing about a system issue that we're trying to correct. Now, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
And you put your hand down. You heard what Ms. Yeski said on your behalf and you signed the written plea form.
Yes.
How old are you?
52.
How much education do you have?
GED.
You able to read and understand the plea form?
I'm sorry, what?
Are you able to read and understand the
Yes,
plea
sir.
form? And did you do that before you signed it?
I'm sorry?
Did you read it and understand it before you signed it?
Yes, sir.
And it's what you read in the plea form, what Ms. Yeski just announced to me.
Yes.
Do you understand by this plea?
Yes, sir.
Excuse me. Do you understand by this plea that you're pleading no contest to the announced charges?
Yes, sir.
And that tells me you believe the state has the evidence necessary to prove your guilt and you're not going to contest that.
Yes, sir.
And do you understand by doing this, you're waiving your right to a trial where the state would have to prove your guilt to the jury?
Yes, sir.
In this case, you'll be adjudicated guilty, be placed on 5 years of standard probation, with the special condition that you must complete the Phoenix house and any aftercare, the restitution that was announced, and you must not be at or about the place that was announced, community service hours and the testing and the substance restrictions, as well as the other fees and costs. Is that what you understood?
Yes, sir.
Ms. Yeske answered all your questions about the plea and how it affects you,
Yes, sir.
and you satisfied with how you've been represented.
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. And we'll set this for 5/14 for status.
And would Your Honor be willing to waive the cost of supervision?
I'll waive the cost of supervision. Yes, probation.
Is this a bars to bed?
Yes, it is bars to bed.
Thank you.
So is it 5 years for each count? Because count one is a first degree felony.
Yes.
So 5 years, counts 1, 2, and 3 concurrent.
Correct.
Okay. Thank you, Madam Clerk.
Right this way, sir. John Dylan Pope.
This is John Dylan Pope before the court in 24 CF 1626. First, Mr. Pope has returned from Florida State Hospital, so we would request that the court enter a finding of competence to proceed in his case.
All right. Does state stipulate to the report?
State stipulation, Your Honor.
All right. The court will find that the defendant is able to proceed at this time.
Thank you. And in this case, we have an agreement worked out. I believe the state just needs compliance with Marcy's law. So we would ask for the continuance to the next date, and we hope to get this set on an earlier plea date.
That's correct, Your Honor. We've worked out an agreement. I just need to speak with the victim to ensure that I explain to them the agreement and what we're doing. If there is a pretrial detention docket next Thursday, our intention is to hopefully be able to set this for an early plea on that docket if there are other pretrial detention hearings being heard.
All right.
Otherwise, set 5/11.
Yes.
All right. Set it for 5/11, and if we have the opportunity, then we'll do it next week.
Good.
John W. Pope.
That info has been filed.
Your Honor, this is Jonathan Wayne Pope before the court in 25 CF 1654, which is a violation of probation. Mr. Pope also has a new case number 26 CF 696. It's not set for today's docket. It's actually set for the May 14th arraignment. However, the state has just filed an information, and we hope to resolve both together today, if the court will allow.
Yes, ma'am.
Okay. So in this case, it will be a no contest plea as charged. In 25 CF 1654, it will be admit to the violation, adjudication of guilt, 3 months in the Okaloosa County Jail with credit for all time served, revoke and terminate probation, pay a $100 violation of probation costs, and $100 cost of defense, $50 public defender application fee. In 26 CF 696, it will be an adjudication of guilt, 3 months in the Okaloosa County Jail with credit for all time served, core costs and costs of defense. These sentences are to run concurrent, although they will not be coterminous, and I've explained that to Mr. Pope.
All right.
If I may approach with the agreement.
Granted. information been filed, Madam Clerk? Both cases?
In the 696, when we found out there's a possibility for us to resolve, we filed it just this morning. I would say probably like 2 hours ago.
Yes,
You ready?
Ready.
Okay, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. You heard what Ms. Yesky said and you signed the written plea form?
I haven't signed it yet, but yeah.
Oh, in fact.
My apologies.
No, it's okay, ma'am. That's the reason we do this.
Your Honor, I have the agreement signed by all the parties.
All right. Thank you. All right. Now you've signed it. And it's what you read in the plea form, what Ms. Yesky announced to the court just now.
It is.
All right. And you've got two things going on, but we're taking care of them together, but they're two different things. You got your VOP and your new charges, right?
Yes, sir.
All right. So as to your VOP, you understand that you're admitting the violation.
I do.
All right. And that tells me you agree with your probation officer that how you violated your probation.
Yes, sir.
And by doing this, you understand you're not going to get a hearing where the state would have to prove your violation.
Great.
As to your new charge, you understand that you're, and as to the 26 CF 696, this is as charged?
It is.
Both counts? Okay. As to that case, you understand that you're pleading no contest to both charges.
Yes, sir.
And that tells me you believe the state has the evidence to prove your guilt, and you're not going to contest that.
Correct.
And by doing this, you understand you don't get a chance to make the state prove that to the jury.
Yes,
You're waiving that. In this case, you'll be adjudicated guilty. And on your VOP, your probation will be revoked and terminated. And you'll be sentenced to 3 months in the county jail, credit for all time served, with the fees and costs that were announced. And on your new case, you're going to be adjudicated guilty and be 3 months in county jail with fees and costs, and those would be, Madam Clerk?
6 weeks for the court costs, $150 public defense.
All right. How much time do you think you'll need to get all your fees and costs paid after you get out?
Probably a year.
Okay. All right. Ms. Yesky answered all your questions about the plea and how it affects you.
She did.
You satisfied with how she's represented you?
Extremely.
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea with the adjudication.
Right this way, sir.
And is this guidelines?
It is, Your Honor.
John Sinky.
Your Honor, can we have a brief?
Yes,
moment?
ma'am.
Your Honor, this is John Sinky before the court in 22 CF 987 on a violation of probation. And for the court's awareness, Mr. Sinky also has a new case, 26 CF 708, which is set for arraignment on May 14th. At this time, we will just handle the violation of probation on the court's docket today and enter a denial. And if we could.
All right, so I got the 22 CF 987, and the other case is?
26 CF 708.
And it's set for when?
A May 14th arraignment.
All right. And we don't have any information on that?
Correct.
Any offer once the information's filed?
Your Honor, I'm handling the VOP in this case, and he has a 60-month suspended sentence, and that would be the state's offer for the VOP resolution.
60 months?
Yes, Your Honor.
Okay. We'll enter the denial and we'll set this case to travel with the new case on the 5/14.
Thank you, Your Honor.
Recall Thomas Cole.
Judge, we're back with Thomas Cole. Jason McKinney on behalf of Mr. Cole on 23 CF 851. Have you had a full chance to read that through? Do you need more time?
No, I don't understand it.
If you need And Judge, Mr. Cole is asking for some further explanation and is asking for me to read him the plea agreement, which I'm fine to do that. Can we bring him back at the 1:30 docket so that I could read this through with him? Or does the court wish to set this up?
Can we do that?
Of course, sir, whatever you ask.
All right. Well, it just as a challenge with transport, I want to be sure that that's possible.
And I need to bring Mr. Cole back at 1:30.
And the end result is going to be a plea to the bench and set off for sentencing, but I want to make sure that Mr. Cole has full opportunity for me to read this through with him. If we could come back at 1:30, I'd like to try to do that.
Yep, that'll work.
And that would be some additional time in the attorney-client.
All right, very good.
Frank, how much of a problem is that going to cause you?
No, that's fine, we'll bring that to 1:30. We got our 12:30 ready whenever the court is ready. Okay. I know we have some out of these, I imagine. That concludes the in custody for 9 o'clock.
All right, so next I've got left Rudolph, Demetrius Rudolph. All right, good morning. You're here today without a lawyer. Do you want a lawyer to help you, or would you like to hear what the state has to say first?
I'll listen to what the state has to say.
Okay. What, does the state have an offer on Mr. Rudolph's case?
Your Honor, can I have a case number by chance?
Sure, it's 22 CF 2613.
Your Honor, as of right now, there is no current offer. And this, yeah, this is not the case. I don't want to speak to this. I can't bring it up.
Approach the defendant briefly.
Yes, you may.
Some drug treatment, the certificate, I believe, is completed everything.
Okay, all right. So you hang around just for a few minutes, they'll try and run that stuff down and then call you back up, okay?
Yes, sir.
All right, thank you. All right, so we've got Mr. Cole coming back, we got Mr. Rudolph. That's it for 9 o'clock. What about Lawrence Rodriguez?
I believe, Your Honor, I'm gonna go forward with pretrial detention. I communicated with the victim, and that's her input.
So we can just continue it?
No, I can go forward to today with pretrial detention hearing.
Okay, all right, so we'll cue that up at 12:30?
Yes, that would be fine.
Okay.
Your Honor, we had an individual, he for some reason was put on the 2 p.m. docket. He entered a plea, I want to say, on the last pretrial dates, and he was to report at 9 a.m. today to go serve his Department of Corrections sentence. He is actually present in the gallery now, and so we're hoping to accomplish that.
All right, call him up.
Anthony Patterson?
And do we have a case number?
Yes, Your Honor, this is case number 25 CF 2297.
2297?
Correct, and there's already been a plea agreement entered into, signed by all the parties, and just needs to be signed by you.
All right.
Court can get 1 alpha.
And do we have a score sheet?
I was under the impression that Your Honor, I will bring the score sheet back this afternoon. I will look it up real quick and let the court know what the guidelines are. The guideline sentence is 17.55 months in the Department of Corrections, Your Honor. There would be the potential exposure of 5 years as a maximum, or 6 years as a maximum sentence. But the score sheet does show 17.55 months in the Department of Corrections.
All right, so this is,
Hold on, Mayor, we may actually have it here. No. There's an updated one we did. I'm gonna have to print out a new.
okay,
a new score
so the sentence is 18 months.
sheet. Correct, Your Honor.
And so it's a departure for a negotiation?
No, it's a guideline sentence.
Oh, it is a guideline
Yes,
sentence?
Your Honor.
Okay. All right, Mr. Patterson, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I did.
All right, can you put your hand down? I've been tendered a written plea agreement.
Yes, sir.
All right, did you sign the plea agreement?
Yes, sir.
How old are you?
6.
How much education do you have?
Graduate.
All right, and you able to read and understand the plea agreement?
No, I don't, but I got to take the agreement.
Say again?
I can't read, can't write.
Okay, so you can't read or write. How do you know what's in the plea agreement? Did Ms. Yeske go over it with you?
He caught went over with me.
Say again?
Your Honor, if I may, we had already tendered all of this, and he was simply reporting, it was with Mr. Koch, and he was simply reporting to...
For the sentencing? How? Oh, this is a copy of the plea. This is not the original.
There's actually one, and he was just reporting to...
For the imposition of the sentence.
Correct.
I apologize.
Sorry, I don't think I fully explained that. Ms. Yeske was not present. when
Okay,
we did this agreement.
so this is simply for the imposition of the agreed upon sentence, and okay.
And you, I believe the court previously done.
I'm now looking at my notes. The original offer is 27.45, and then it came down to the 18 months.
Correct.
And we took the plea on 3/11 with deferring sentencing today. I admonished the defendant that if he got new charges or failed to appear, that it was an open plea to the court, And so we're now just imposing the sentence.
Correct, Your Honor.
Okay.
I will make sure to be a score.
18 months Department of Corrections, credit for time served.
Ready to spend this payment, Judge. Is our next thing up the 12:30 docket, Your Honor?
After this, that's it.
Judge, may I approach?
Granted. Right. She said I revoked a bond at first appearance.
Your Honor, if we could call one more case. It's Jennifer Sean. She's actually set on the 12:30 docket.
Is that with AJ?
It's with
David?
Assistant State Attorney David Snell.
Yeah, it's an early plea.
And I believe jail booking already has her up.
Yep, she's just gotta move something around and then we'll get her out here.
Okay.
No problem. With the court commitment, just for that.
Okay.
Is any, do you have court?
Yes, I do. It was at 9.
What's your name?
Desiree Couch against Convenience.
Desiree Couch.
We were both here and he just left.
Is it?
You are the defendant?
Suing him.
That would be a
For
different court.
restraining order.
Oh, you should have been at Judge Brown's courtroom.
And it's probably already been.
It's probably already done.
Let them know.
Hey, you just miscredited my 15. We got a Jennifer Dodge.
Yeah.
He was supposed to be in injunction court. She's already left, I'm sorry, young man. You'll make your way over to that lectern right there?
Go right here.
Jennifer Shan.
Your Honor, this is Jennifer Sean before the court in 25 CF 1750. We have come to an agreement in her case. We just need the state attorney to sign it.
All right.
And we do have Lawrence Rodriguez available. I don't know if you want to wait till 12:30.
Who is?
Lawrence Rodriguez, the one that we're going to have a PTD on.
I don't know, it depends on if Ms. Leone has her witnesses.
Okay.
We're ready.
All right.
In Ms. Sean's case. Again, case number 25 CF 1750. Ms. Sean will plead no contest as charged. It'll be an adjudication of guilt, 60 days in the Okaloosa County Jail with credit for all time served, and the state stipulates that the time has been served. Court costs, a $100 cost of defense, and $50 public defender application fee. And I have the agreement signed by all parties. If I may approach.
You may. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. You can put your hand down. You heard what Ms. Yeske said and you signed the written plea form?
Yes, sir.
Okay. That's okay. Just take your time. Take a deep breath. It's okay. How old are you?
52, sir.
Okay. You able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And it's what you read in the form, what Ms. Yeske just announced for me.
Yes, sir.
Do you understand that you're pleading no contest to this charge?
Yes, sir.
And by doing that, I understand you to tell me you think the state could prove your guilt and you're not going to contest that.
Yes, sir.
Do you understand by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
All right. You'll be adjudicated guilty, get credit for time served with 60 days in the county jail, and the state stipulates that you've already served that time.
Yes, sir.
And you'll have the fees and cost of how much, Madam Clerk? All right. And I'll give you a year to pay if that's enough time.
Oh, yes, sir.
Ms. Yeske answered all your questions about the plea and how it affects you.
Yes, sir. And it'd be okay if I paid that before that time, right?
Absolutely.
Oh, yes.
Okay.
Once it's paid, then it'll be over. You just have that amount of time to get it done.
Okay, yes, sir.
And are you satisfied with how you've been represented?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you, sir. Do I have to come back to court when I'm paid the fine?
No, you can do that with the clerk's office.
Oh, okay. Yeah, okay. God bless you.
Stuff so that the client can sit in the community. Okay, no problem.
I was hoping we could get done a little early and have a break. You ready, Mr. Snell?
If I could address Mr. Rudolph's case.
You may, sir.
So, it looks like, you can ask questions, but don't ask me, you need to ask the court, okay? Did it have something to do with,
Yeah, some of that. They were saying that.
okay, well, let me tell the court what we found out. And then recess you gave, so we were able to confirm that he has completed the treatment and evaluation, and he has supervision fees and court costs outstanding. So what the state would recommend, request the court to do would be to extend his probation for a year and to give him time to pay the court costs and have automatic early termination once he has a chance to pay that, because he's not working yet, but he believes he's gonna have a job soon. And he can pay that off and won't suspend his driver's license. If you could waive the cost of supervision and the arrearages, that would cut it probably close to, a significant portion of that. And give him a chance to go ahead and get that done. And once he gets to the outstanding money paid, then he can automatically return.
So the only outstanding condition at this point in time is financial.
That's correct.
Would the state be willing just to allow him to terminate and then give him a year to pay his financials to the clerk? That way the burden is on him. He doesn't have to worry about reporting. He doesn't have to worry about any of those other conditions.
I'd be fine with me if that's.
Then the burden's on you to be sure it gets paid, because if you don't pay it within the year, then the clerk's going to send it to collections and it would affect your driver's license.
Yes, sir.
Can you do that?
Yes, sir, I can.
And as long as you're making payments, if you run short for whatever reason, you can ask for additional time and I'll give it to you as long as you're making payments. If you're not making payments, don't ask for more time.
Yes, sir.
Yes, probation, is there something else?
Yes, we were just told that he also has community service hours he did not complete.
I didn't realize that.
Yeah, I didn't either. We just got word.
Okay, so
Officer, when I was talking to my probation officer about that, he said that I could pay it off.
well, and I'll let you do that, but at the same time, it's going to be hard for me to do that and not keep you on probation because of the consequences, because it's hard to do that, to pay it to the clerk. There's lots of stuff to do that. So, Mr. McKinney, what would you suggest?
I would suggest you continue it to 5/14, see if he can pay off those community service hours, and then get back to the original decision.
Think you can do that?
Yes, sir.
Okay, so what we'll do is we'll continue to 5/14, and if you can get those paid off, then we'll go back to the original situation, which was allow you to terminate, then you can pay your balance of your costs to the clerk over a year.
Yes, sir.
Okay?
Lawrence Rodriguez, pretrial detention hearing.
All right.
Your Honor, this is Lawrence Rodriguez in 26 CF 717. He's appearing before the court on the state's pretrial detention motion. Would you like us to be seated from council table?
You may be seated at council table.
Thank you.
Yes, Your Honor, the state would call Sergeant Jessica Trimboli to the stand.
Sergeant Triboli, what's your step? When you get to the docket, go ahead and stand and face the clerk and raise your right hand.
Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Please be seated and direct your voice to the microphone. Speak clearly and distinctly so we can all hear and understand you, and also the court reporters are able to make a good record. If one of the lawyers objects, stop speaking until I give you instructions. Is that okay?
Yes, sir.
Okay. You may inquire, Ms. Leone.
Thank you. Sergeant, state your name and spell your last name for the record.
Jessica Trimboli, Trimboli.
What's your occupation?
Sergeant at the Okaloosa County Sheriff's Office.
How long have you been so employed?
For 14 years.
And in this capacity, how long have you been a sergeant?
Since 2021.
Now, prior to being a sergeant, prior to your promotion, what was your rank?
I was an investigator.
Were you an investigator in 2019?
Yes.
And were you assigned to investigate a report involving the Rodriguez family?
Yes, ma'am.
And what was the nature of the initial report?
The initial report was physical and sexual abuse occurring in the home.
And who initially generated the report, and how did it come to you?
My particular involvement generated from the SRO receiving a school resource officer receiving a disclosure at Niceville High School.
What was the nature of the disclosure?
The disclosure was one of the juvenile females in the home disclosures physical and sexual abuse occurring in the home in Niceville, and that there was sexual abuse in the home in Navarre as well on a multitude of the children.
If you can state just the first name of this particular minor who disclosed to the school resource officer.
The first disclosure was made by Angelina.
And what did Angelina disclose?
Angelina disclosed, it's a lot of different details, but Angelina disclosed that there was a lot of physical violence occurring in the home between Mr. Rodriguez, her stepmother Celia Rodriguez, her older brother Nathaniel, her younger sister, who's the victim in this case, herself, as well as sexual abuse that previously occurred on Angelina being the victim in Santa Rosa County, as well as sexual abuse on her younger sister, who's the victim in this case.
What's her name?
Jasmine.
How old was Angelina at the time she made the disclosure? Approximately.
I believe she was 16 at disclosure time.
And how old was Jasmine at the time of the incident that was disclosed?
At the time of the incident in this case, she would have been approximately 13.
When those events were taking place, can you tell the court the composition of the family, who was living and how they were all related to one another?
So it's a little bit of it's a mixed family, a blended family, if you will. So Mr. Rodriguez was the father in the home. Celia Rodriguez was the mother in the home. There was Nathaniel, the older brother, Julian and Angelina. Julian's a brother. He and Angelina are approximately around the same age. Jasmine would be the next child. Then you have Lawrence Rodriguez Jr. below Jasmine, and then you have Lauren below that. So there were 6 kids total. I believe, if I'm not mistaken, 3 were the mothers, 2 were the fathers, and 1 were their shared child.
Now, is Angelina Mr. Rodriguez's biological daughter?
Yes, ma'am. Angelina is biological to Mr. Rodriguez.
And is Jasmine his stepdaughter?
Jasmine is Celia's biological, Mr. Rodriguez's stepdaughter.
Do you know approximately how long the defendant lived with Jasmine?
According to my case, from all of the information we gathered, it was approximately 10 years.
And based on your investigation, did you determine that the defendant had a parental role towards Jasmine?
Yes, ma'am.
What's Jasmine's date of birth?
Jasmine's date of birth is June 11th, 2004.
During, in the beginning of the investigation, following the disclosure, was DCF called and involved?
DCF was involved prior to my involvement.
Do you know if what the DCF investigation entailed and what resolutions or temporary resolution they found?
There were several things that came up throughout the case prior to probable cause being initiated from law enforcement, but throughout the case, there were removals of the children from both parents, and they were separated.
So did you participate in forensic interviews of the children in this case?
Yes, ma'am.
Do you remember whose interview did you watch?
If I'm not mistaken, I was present for all of the forensics at the CAC that were accomplished.
And those interviews obviously were recorded?
Yes, ma'am.
What can you tell the court about the interview of Jasmine on May 10, 2019? Did you observe that?
Is that the first attempt at the forensic?
Yes. Yes, May 10 was the first, and then I think you indicated in your report that was a second interview of Jasmine.
Okay, so May 10th, we weren't able to get the CAC forensic interviewers to do the normal forensic interview because there was no disclosure from Jasmine. So this was handled based on her age being 14 at the time. This was handled with DCF and myself just interviewing her on May 10th at the CAC.
So to clarify, on May 10, when she was first interviewed, she denied any allegation of improper conduct from her stepfather?
Yes, ma'am.
And then, was there a second interview of Jasmine?
Yes, ma'am.
When did that take place?
Approximately 5 or 5.5 months later.
Does October 25, 2019 sound familiar?
Yes, ma'am.
Do you by any chance recall, during that time, during the interview of October 25, 2019, where the defendant was?
The defendant was incarcerated.
Now tell the court about the interview, Jasmine's interview in October, please. Did she disclose?
Tell the court, yes, ma'am. That interview took place on October 25th because Jasmine had communicated to her guardian ad litem and her foster parent at the time that she was ready to talk to law enforcement based on Mr. Rodriguez being incarcerated. In his incarceration at the time, we had, I believe, 2 to 3 years from that conviction of the violation of probation, so she felt secure in making a disclosure at that time.
Now you mentioned violation of probation. Are you aware if this defendant was convicted prior to this incident to a felony where Jasmine was the victim here in Okaloosa County?
I was not a part of that case, but from the information I gathered during my investigation, he was actively on probation for the offense against Jasmine previously that involved strangulation.
Your Honor, I would like to ask the court to take judicial notice of Okaloosa case 4617 CF 2559.
Objections to notice?
No objection.
Notice is taken.
Thank you. What did she disclose? What did Jasmine disclose during the October interview?
Jasmine's disclosure was that she was 14 at the time of the disclosure, and for approximately 3 to 4 years prior to that, her dad had been sexually abusing her almost every day. And she described, based on my training and experience, sexually abuse could be meaning a whole bunch of things, so we had her describe that meant intercourse between penis and vagina.
Did she mention how she felt about the defendant? Was she afraid of the defendant?
In the October interview, she said she was afraid of him because he had explained to her that he would kill her, harm her, her family, if she ever told anybody, and ruin the family.
Based on your investigation, do you believe that Jasmine's thoughts and fear was substantiated by actions that were happening in the family?
Yes, ma'am.
Did the other children ever disclose incident of violence in the family that they observed?
The only one that fully disclosed would be Angelina. The others in their interviews sort of touched on it, but a lot of them it was early on in the investigation, and a lot of them still appeared sort of coached or following direction of the defendant.
During your investigation, did you learn that Jasmine had become pregnant at
Yes.
some point?
Yes, ma'am.
And when did the pregnancy occur?
So let me see if I can find the right page. It was in 2018.
Around August?
That sounds right.
And do you know how this pregnancy was discovered within the household?
The Jasmine, according to the testimony, she had missed a few menstrual cycles. She had already started her menstrual cycle at the time, missed a few months, and then one of her parents purchased her a pregnancy test to take it. At that time, according to the testimony I have, Mr. Rodriguez took the pregnancy test to read the results. Jasmine had already seen it at the time, and then not too long after, her mother, Celia, drove her to an abortion clinic.
Now, do you know where they went, which clinic they went to?
All of the records were pulled from the Department of Children and Families, but during the investigation, it was learned they started at the Tallahassee abortion clinic. However, she was too far along at 16 or 18 weeks. And because of that, the only clinic in the state of Florida that they could find, I believe, was the one in Jacksonville.
Who took Jasmine to have that abortion?
Celia Rodriguez, her mother.
And Celia Rodriguez is Jasmine's biological mother?
Yes, ma'am.
Do you know if Ms. Rodriguez was aware of defendants molesting her daughter?
I believe through text messages and testimony from the other kids and from Jasmine herself that her mother was aware.
Yeah, and also you're aware Ms. Rodriguez was prosecuted.
Yes, ma'am. I arrested her for failure to report.
Right, yes.
Yes.
And was DNA obtained from the pregnancy and the abortion?
DNA was attempted to be obtained. However, by April, when this case started, and by the time the records were found, the only thing left at the abortion clinic to provide any evidence to this case was the documentation. The evidence had been already destroyed at the abortion clinic.
And how old was Jasmine at the time of the abortion in 2018?
She was 14 when I talked to her. I believe she was 13. 13 at the time of defense.
Now, you mentioned, and I just don't want you to be don't have to be very specific.
Yes.
You mentioned text messages.
Yes.
Right? Was a phone downloaded during the investigation?
Yes, ma'am. In a separate offense case, Angelina's phone actually was retrieved by law enforcement and downloaded for a separate offense, and text messages related to this case were discovered during that separate offense phone download.
Generally, and summarizing the content of those messages, could you tell the court what they were about?
There were text messages from Celia directly talking to Angelina, telling her to keep Jasmine out of Mr. Rodriguez's room, saying that she felt something bad was up, things alluding to Jasmine and Mr. Rodriguez having a relationship, things alluding to coaching of the children. For example, when Families First Network was coming to do home visits, there were messages saying, tell them I don't know, or something like that, so that the Families First wouldn't, ask further questions. But the bulk of the text messages that were important to our case were between Miss Celia Rodriguez, who is Angelina's stepmother and Jasmine's biological mother, talking to Angelina about Mr. Rodriguez and Jasmine's relationship.
Do you recall at all Lawrence Jr.'s interview?
Lawrence Jr., slightly, yes.
What did he disclose during his forensic interview about his relationship with the father?
He said he loved his father. He said the things that caught me off guard were the things that he wished that there was a family without violence, or, he would cover his ears or something like that when yelling would take place or physical abuse would take place, because he witnessed some of it.
Did he disclose that the defendant instructed him to lie about when he would be questioned about the violence in the family?
Yes, one of the things I thought was interesting was during his interview, he said it was hard to keep everything in order, the lies in order.
Do you know anything, or did you review any psychological evaluations of the kids?
During the case, not recently, though.
Do you have any recollection based on your review in the past of those records?
Yes.
What were the results of those evaluations?
They were all positive findings for physical. I believe the psychological were only Angelina and Lawrence Jr. So the physical and sexual on Angelina, and the physical and neglect, something, I forget the wording in the psychological evaluation, it's different law enforcement, but both of them were positive findings.
So there were findings that those kids had been injured?
Yes.
Either mentally or physically or both?
Yes, ma'am.
During the investigation, was the defendant interviewed?
Not by me directly. I believe he had conversations with Department of Children and Families. He was incarcerated through most of my investigation.
Now, how long would you say that the sexual abuse of Jasmine lasted in the hands of this defendant?
According to Jasmine, it began in 8th grade, which is the same as when it began for Angelina. So if in 9th grade she was 13, so I would say probably 11 or 12 until this case started, and it hasn't continued since, obviously, since he's been incarcerated.
Based on what you know about the case, do you think that there is a potential risk of this defendant retaliating and intimidating Jasmine or other witnesses?
Yes, ma'am.
Are there other minor children besides Jasmine, of course, who would be at risk if this defendant was released?
Yes, there's 6 total.
Do you have reason to believe that this defendant would become or is aware of the whereabouts of Jasmine?
I believe it would not be hard to find.
Do you know if he's still in contact with his family members?
I don't know directly, but I believe so.
Have you been made aware of phone calls from the Department of Corrections to his kids?
I've been made aware that the oldest child has warned our victim to watch her back based on the potential for the defendant getting out.
Based on your training, experience, and knowledge of this case, do you believe that Mr. Rodriguez is a danger to the community and to minor children?
Yes, ma'am.
Do you believe that to ensure the safety of the victims, the integrity of the judicial process, he should be held without bond?
Yes, ma'am.
Thank you. No further questions.
Ms. Yeston.
Good afternoon. I just have a few questions. So who was present for the initial interview?
Which one specifically?
Sorry, the initial interview with the alleged victim in this case. I believe you testified May 10th.
May 10th, it was the Department of Children, Families, and myself.
And
the victim, Jasmine.
Okay. And then who was present for the second interview? I think you said October 25th, 2019?
Yes, ma'am. Myself, I believe there was a foster parent maybe involved, maybe at the table. I don't remember her name. I'm sure it can be found. And then our guardian ad litem, Melissa Wimmies.
Okay. And then the alleged victim.
Yes, ma'am, sorry.
And so you testified that a DNA test was not done on the aborted child.
Correct.
And has there been any physical evidence uncovered from your investigation that supports sexual abuse?
Yes, ma'am. Text messages.
Physical, okay.
Well, I would say, okay.
I see what you
That's
mean.
not, yeah.
Physical evidence from the body of the alleged victim.
No, ma'am.
Now, you testified that you believed the alleged victim felt more secure in the second interview. Why did you feel that way?
I didn't feel more secure.
That the alleged victim, you believe the alleged victim
I got
felt
you.
more secure.
She said she felt more secure because she knew he was incarcerated for a few years at that time.
And she told you that?
Yes, ma'am.
Okay.
Well, if not me, then it was her guardian ad litem and her foster parent who explained she was ready to talk to law enforcement.
Okay. Did you know that Jasmine had been contacting Mr. Rodriguez while he was incarcerated?
At the Okaloosa County Jail?
I believe the Santa Rosa jail?
No.
Okay. And do you know where the alleged victim lives now?
Yes.
Okay. Is it in this state? That is all the questions I have. Thank you.
No redirect, Your Honor, and witness can be excused.
All right, the witness may be excused.
And the state doesn't have any other witness at this time.
Your Honor, at this time, I'd like to call my client to offer testimony.
You may do so.
And this will be testimony related to bond conditions.
No, it's right there, it's fine. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, I do, sir.
All right.
Mr. Rodriguez, can you explain to the court how long you were imprisoned before coming here?
I believe I was incarcerated from 2019 up until now. I haven't been released since then. And also in 2018 and early 18.
And so you have a few different cases. You have a Santa Rosa County case, correct?
Correct.
And at one point you were placed on community control.
That's correct, yes, ma'am.
Did you have any violations while you were on community control?
No, ma'am. No, ma'am.
Okay. And are you still serving, or do you still have more of your sentence left to serve in the Santa Rosa case?
No, ma'am. Completed all that sentence.
You completed the incarcerated sentence. Do you still have probation?
I still have probation, yes, ma'am, to complete 5 years.
5 years of
Yes, ma'am.
probation? Okay. And how much money do you currently have?
At the moment, I have zero in my name, but I have a great support system out on the outside. And a job lined up and a trade to go to.
What would that job be?
I'd be HVAC, done that my whole life. So it'd be a job lined up. The housing would be pretty much like a program out here, REAP. I mean, I have a support system. I just got to get with them to see what's going on.
And you mentioned, would you have a place to go if you were released?
It'd be, at the moment, it would be pretty much a homeless shelter, I would believe, and we'll start from there. Or I can contact the resource that I have, and that they will be able to place me in a home.
And do you believe if the court set conditions on not contacting certain individuals, would you be able to comply with those conditions?
By all means.
And do you intend to complete your 5 years of probation in Santa Rosa County?
Correct, yes, all 5 years. I've done, pretty much done prison.
Okay. Those are all the questions I have at this time.
I have a couple of questions, Your Honor.
You may do so.
Mr. Rodriguez, you mentioned you were serving a sentence. What was the sentence for? The Santa Rosa case?
That sentence was, I believe that was for, I believe, third degree. I really don't know a lot about law, so I'm not going to sound like I do. So it was pretty much, it was for the other case that you had mentioned. It was like a third degree, that's all I really know. Like 5 years, and they gave me 5.
Who was the victim in your case?
Angelina Rodriguez.
Okay, who's Angelina?
She's going to be my daughter.
And what did you do to her in that case?
I didn't fight that.
What's the objection?
I would object that I solely asked about his sentence, and now we're getting into the facts of a prior case.
How would this be relevant? What factors does this go to?
Danger to the community, present and past conduct.
Overruled. Answer the question, sir.
Oh, what was the question when we're done?
What did you do to Angelina in that case?
During that case, I didn't fight that case. I didn't put no much effort into it because I guess I felt like, you know what I mean, I didn't know a lot about law. So what I did and what the paper says and what y'all have on record probably won't go with my mind what I'm thinking it is. So I can't say exactly without misinterpreting or saying the wrong thing to you. So I'm not gonna lie to you. I have no idea.
Yes, sir.
I just know it's a third degree.
Thank you. But you agreed to serve 5 years in prison for that?
Yeah, it was pretty much where, like, the point where you're like, okay, let me just sign and get it over with.
Yes, sir.
I'll deal with it when I can, you know, as my life goes on, just as now.
Were you also convicted in Okaloosa County for crimes against Jasmine?
Yes, one more time, yeah, it was.
And do those charges were based on your violence towards Jasmine?
That's what that case was, and I placed on CC, and it had no technicals or no violations. Her name was Heather King, who was my probation officer.
Great.
CC. They went by every day, and so did
Yes, sir. Now, you don't have any ties to this community, correct?
The only ties I have here was, I just worked out here, and that's really not a lot of ties. But now that I have this probation, I do have ties here. I gotta pay back to that society, and that's pretty much where I stand legally on this behalf.
Thank you. And you mentioned that you do not have a residence to go to. You will go to a homeless shelter.
Due to me being in prison, incarcerated, I really don't have a foundation because I didn't have a job. They don't pay you in prison. But as my release and I start my life again, that should be easy to come by because I have a trade. It's not a job. It's pretty
Yes, sir.
HVAC, it's high demand at the moment.
Now, you knew that Jasmine became pregnant back in 2018, right?
I was incarcerated during that time, so I really don't know what was happening out in the free world.
But you knew she was pregnant at the...
Objection, Your Honor. I would object that the pregnancy is not, we don't have DNA evidence to show that Mr. Rodriguez is the cause of that pregnancy, and we'd argue that it's not relevant for this pretrial detention, and also beyond the scope of my questions, which were bond.
On that basis, overruled.
Thank you. No other questions, Your Honor.
All right, any redirect?
No redirect.
Okay. All right, you may be seated. Arguments?
Yes, Your Honor. Your Honor, the state moves for an order of pretrial detention pursuant to Section 907-041 Florida statutes and Rule 3.132 Florida Rules of Criminal Procedure. The defendant stands charged today, and the state has filed already an information in that case, with sexual battery upon a child by a person in familial or custodial authority. And this is a life felony under section 794-011-8B. The charge alone would trigger a presumption in favor of detention under section 907-041. But this is not a case where the state is asking the court to rely just on that presumption. As the state has demonstrated through the testimony of Sergeant Trimboli, we have substantial evidence which is corroborated from multiple independent sources. The standard before this court is whether the state has demonstrated that no conditions of pretrial release will reasonably protect the community from the risk of physical harm or assure the defendant's appearance at trial. There is a substantial probability of guilt. Court has heard from Sergeant Trimboli about the investigations. The evidence establishing a substantial probability that Mr. Rodriguez committed this offense comes from multiple independent sources. One, the victim's own disclosure. Sergeant Trimboli testified that Jasmine was interviewed twice, one time in May of 2019 and then another time in October of 2019. She first denied that anything happened and later disclosed that she had been raped repeatedly by her stepfather, Mr. Rodriguez. She waited to disclose because she was afraid of retaliation, repercussions. She was well aware of the amount of violence this defendant could do to her. I've asked the court to take judicial notice of the Okaloosa County case, the 2017 case. The reason for that is because in that case, the record of first appearance includes photos of injuries, visible injuries, sustained by Jasmine in the hands of her stepfather, Mr. Rodriguez. In that case, he was convicted of strangling Jasmine and then also resisting arrest. There was another pending case, and the pending case is relevant to this one, is the one that involves his biological daughter Angelina out of Santa Rosa. That's important because the whole disclosure of Jasmine happened because of that case. In that case, the allegation were that Mr. Rodriguez had inappropriately touched Angelina, his biological daughter. And as he claimed, and he testified, he was sentenced to 5 years in the Department of Correction, and then he was going to follow with probation. Therefore, this offense is not an isolated incident. It's not a mistake. It's not something that he hadn't planned. What's also very important is the attempts of this defendant in coaching the other minor children in lying to authorities when they were interviewed. What else do we know about the case? That's something, yes, we don't have DNA, but why do we don't have DNA of the pregnancy, Your Honor? Because there was an active concealment of that evidence by the parents, by both Celia Rodriguez, who was Jasmine's biological mother, and this defendant. They wanted to hide it to the authority. She was so far along, 16 weeks, that local clinics wouldn't take her for the abortion. They had to drive all the way to Jacksonville to get that done. And all the evidence, all the DNA, obviously, was disposed of by the time that this whole case came to the surface. What else do we have in this case? Sergeant Trimboli testified that we got a hold of text messages clearly indicating that the whole family was aware that there was an inappropriate relationship taking place within the family between the defendant and Jasmine. Let's not forget, Jasmine was 12 years old, at least when it started, and she ended up having the abortion in August of 2018 when she was 14, or barely 14. The state believes, Your Honor, based on the pattern of conduct of this defendant, based on the crimes that he actually was convicted for, based on the fact that he's been coaching these children, the fact that he has retaliated and used violence against his own kids to keep them from speaking out. It's a great danger. He controlled with violence and retaliation the whole family, including his wife. He was convicted, as I mentioned, in 17 CF 2559 of child abuse against Jasmine already. He strangled her. And the strangulation and the violence in that case was actually documented with physical injuries and photos showing the injuries. This defendant abused Jasmine in this case every day for years inside the family home where she should have felt protected with a person she considered her father, this defendant. It's not a single incident where the defendant can show regret and has his own attitude as demonstrated to this court. When I asked him about the case in Santa Rosa, he acted like he didn't even know why he went to prison, therefore not taking responsibility for what he has done. I don't believe, the state does not believe, Your Honor, that any GPS monitor or any condition of bond could protect these children from this defendant and maintain the integrity of the judicial process. Additionally, this defendant has stated that he doesn't have any ties to this community. He doesn't have a job, he doesn't have a residence, he does not have family. I believe that, again, there is no condition that can protect the community from this defendant, and the state asks the court to please impose pretrial detention.
Ms. Yes.
Thank you, Your Honor. I'd like to focus on the fourth prong of the pretrial detention statute. You heard testimony that Mr. Rodriguez was previously on community control with no violations. You heard that he has a plan and that he has 5 years of probation that he fully intends to comply with, and he has already served a 5-year incarcerative sentence. In addition, Your Honor, his Santa Rosa County case was a no contest plea. He did not contest the charges. And in doing so, he accepted a 10-year sentence, 5 incarcerative, and 5 on supervision. The allegations in this case are from at least 7 years ago, and since then, he has been serving an incarcerative sentence. We also heard testimony that the alleged victim in this case does not live in this state. And in the first interview with the alleged victim denied the allegations. And Your Honor, the pretrial detention statute requires that there be no conditions of pretrial release that can reasonably protect the community from the risk of further harm. I would argue that the whole purpose of him serving an incarcerative sentence is not to continue to be punished, but to serve his punishment and move on from it. He's here today, and based on my conversations with him, he intends to resolve this case. And due to that, Your Honor, we would ask for a bond rather than a pretrial detention. As you heard, he testified that he does not have money, but he has a plan. He'd be working with the REAP program, and he intends to follow all court requirements. Thank you.
Any rebuttal?
No, Your Honor.
All right. The court, we know the appropriate statute, right? And the statute tells the court that if the court finds a substantial probability the defendant committed the offense and, based upon the defendant's past and present patterns of behavior, consideration of the criteria 903046, and other relevant facts, that no conditions of release will reasonably protect the community from a risk of physical harm, ensure the defendant's presence at trial, God bless you, and assure the integrity of the judicial process. So that's where we are as far as what the court is to find. Now let's review where we are. Now first, based upon what's been presented from the testimony, the court does find that there's a substantial probability that the defendant committed the offense. And the court does understand that it's not clear the definition of substantial probability, but we have quite a few cases. We don't have any case right now that defines substantial probability under the provisions of the 907041 statute. However, we have lots of cases which discuss what that standard is, and the court finds clearly that the state has met that standard on substantial probability the defendant committed the offense based upon the evidence that's been presented. And let's talk about, and the way the statute is written is kind of goes in reverse. Because it says that the court's supposed to talk about the past and present patterns of behavior in consideration of the criteria 903046. And we know that 903046 criteria are the standard criteria that court considers in every matter establishing a bond, right? Those are the set criteria: connection to the community, past and present behavior, and so on and so forth. But the way the statute is written, it kind of tells the court to look at these in reverse order. So, and what the court is looking at now is the past and present behavior. So let's look at that past and present behavior. We know that the defendant's presently in prison after accepting an agreed upon plea in the case in Santa Rosa County, which was a 5-year sentence for lewd and lascivious behavior. The court observed the defendant's demeanor where after being in prison for 5 years, he claims he doesn't even know what his sentence was for. Clearly that demonstrates a lack of candor to the court, a lack of acceptance of responsibility, even though his plea agreement clearly says that he accepts and understands that the facts alleged and the information and presented are sufficient to support his plea in the case. Now let's talk about the other case where he was sent to prison for 30 months after violating his probation 4 separate times, including 2 FTAs where the court revoked his bond and held him without bond, later giving him probation, all indicating that lack of compliance. And his candor here, what was that sentence for? I don't really understand what it was for. And he spent 30 months in state prison for that, which was an agreed upon downward departure on the original charge, which was aggravated child abuse, for beating his child with a belt repeatedly and choking her. And he served that sentence and completed. We have heard testimony that the defendant, children who are in contact with him remain, or there's some contact, circuitous contact, remain in fear of the defendant, and so the court's considering that. So considering all of those factors all put together, and now let's talk about the traditional 903046 factors. The defendant is just completing a sentence. The defendant says, oh, maybe I'll live in a halfway house. I hope to work with REAP. I've heard no concrete evidence of that. He has no family or place here. He did indicate that he had a specific job in mind based upon his prior work, and so that would be a factor in his behalf. However, based upon the history of failure to appear and based upon his history of failure to comply, the court does not find that those factors mitigate the other conditions, the other factors that the court has described. Therefore, the court does find that there are no conditions of release or bail that would reasonably protect the community from risk of harm, and most specifically, the victim in this case and the other family members who could assert pressure on the victim in this case and not to participate meaningfully or be fearful of the victim in this, fearful of the defendant in this case. And I also do not believe that, based upon what I've heard and based upon the defendant's past behavior, that any conditions of bond would ensure the defendant's presence at trial or ensure, based upon the potential for coercion or intimidation of the witnesses or the victim, to assure the integrity of the judicial process. And therefore, the court finds that the state has proved beyond a reasonable doubt that pretrial detention is appropriate and necessary in this case, and the court does so order pretrial detention. And I direct the state provide an appropriate order.
Yes, Your Honor.
All right. And we're set for what date on this case, Madam Clerk?
All done with that one, thank you.
All right, 6/11 for arraignment.
Can I approach one?
Yes, ma'am. Yes, sir. Now, we got other folks in the courtroom, but we probably should take a lunch break at this point in time, right, for our 1:30 docket. Do we have other people on the 12:30? I see somebody who's returned from the morning docket, right?
Yeah, we have another pretrial detention hearing.
We have another one.
Yes, sir.
Who is that?
His last name is Stewart.
Your Honor, if the court would allow, I have something I need to clarify from this morning on the record as well.
Okay, yes, sir.
Judge.
And who is this, please?
Mr. Rosario, Your Honor.
And
this
this
was a
is
case on the morning.
25 CF 1068.
Yes, sir. We resolved this case by plea this morning. However, after we reported to probation and reviewing the file, there's a couple of amendments that need to be made to the order. Just to clarify the record, we want to make sure it's on the record. So Mr. Rosario entered a plea this morning. However, you know, both the state and I were under the impression that the withhold would prevent the necessity of a sex offender designation by requirement. We believe it does require a sex offender designation after discussing with probation. Plus, I've pulled the statute, and unfortunately, why I appreciate the state's being willing to do that. I just think that needs to be documented in the court on the record that he is going to be designated as a sex offender by statute, by requirement. In addition, GPS was not a requirement on the, it's technically down in some verbiage that my client reviewed with me, but it was not written out in our plea agreement. But he is going to be required by statute to have GPS. We would ask the court authorize that at $1 a day. It has already been affixed by probation. He's already checked in. I believe that addresses all of the issues we talked about. Is that right?
I believe so, yes.
All right.
Yes.
We just feel like on a case like this, it needs to be documented on the record in the court file.
So, and of course, that is a substantial change from the original plea, even with a withhold. So you discussed with your client the change in the designation and how the designation affects him.
About future reporting and all of that.
And in present circumstances, it's going to affect where he can live, who he can be around, where he can work potentially, and other consequences, right?
All of those are already, because he's under sex offender sanctions under his current supervision.
Okay.
So all of those things would still apply.
Yes, and one more thing, he works after his curfew hours, so if we can also state that he can adjust his curfew hours for work.
If we could, Judge, I know probation normally does that, but we can put that on the record, that his curfew hours can be adjusted based on his work schedule without having to come back to court.
All right. So, and you discussed all of this, and the defendant is willing to continue forward with the plea agreement, notwithstanding these changes?
We have, Judge.
Okay. Is that true, sir?
Yes, Your Honor.
Okay. All right, so sex offender designation is required. You'll submit an order. GPS is affixed. The court will amend that at $1 a day, and the court authorizes the department to adjust the curfew as required by the statute for work purposes.
Anything else you need to make sure? Great.
Okay.
Thank you. No, nothing else.
That addresses everything that we have before the court, Judge. Thank you.
All right, thank you.
Yes, sir.
So I apologize, I did not have short on my docket. So we have the additional pretrial detention for short, is that right?
Yes, sir.
All right.